All right, let's recall the Hoffman case, 2417-146, here for sentencing. See where we're at least. Got to stretch your legs occasionally, counsel. Mr. Hoffman is in the courtroom. Mr. Stocks represents the state and is appearing by video. All right, let's start. Ms. Isaacson, you've had a chance now to review the sentencing images that state wants the court to review. Do you have any objections to those?
So we had a chance to review 2 files, and there was clarification that the files that they want you to view are related to this case. They are files that were sent to law enforcement from KIC in this case. Given that, we'll leave it to the court's discretion.
All right. I can view those. Deputy Levitt, if you want to somehow show those to me. Do they have audio? Or are they just, okay. Well, let's see. If you like, I can come around. Yeah, I want to come around. And, just let's see. All right, the court has reviewed 2 files depicting obvious prepubescent children engaging in sexual activity. Both were video files. All right, Mr. Stocks, when you're ready, you can go ahead with your recommendation.
Your Honor, I think the court viewed children being raped, and I think this is where this whole case starts off. We look at the PSI, and there is a substantial amount of images, 100 images. And although the defendant didn't plead to all of those, that was what was found. Now, he had a KIC account, and that KIC account was sending out those images and those videos to the point that law enforcement received them. The difficulty in these cases is Mr. Hoffman, we can see in his statement that he substantially downloaded all of those items, but he also downplays his involvement in the entire case. He states that he was ill at a certain point, and that caused him to gain a pornography addiction, and that eventually led him into downloading chat apps like, he says Kim, but I think he means Kick, to find pornographic material that eventually led to me seeing child pornography. And I take issue with child pornography. This isn't child pornography. This is rape. And he states, I would occasionally view and save files and videos, knowing and always feeling very wrong about it. This is a substantial deviation from accidentally falling into the wrong type of pornography. This is perpetrating on those children. This is sharing their videos and exchanging those videos in exchange for sexual gratification. And that's what he was doing while looking at those videos, was for sexual gratification. The PSI walks through the age ranges of the children, 5 to 8, 9 to 12, 12 to 15, 8 to 11, 3 years old, possibly 8 years old. That is horrendous. I think these are a special mitigating factor. If we look down at 7A, if 3 years old, if a child is 3 years old, I believe that individual is exceptionally close to the age of a toddler. We do not have 10,000 images, but what we do have is an opportunity to send a very clear message to the defendant. This is not appropriate conduct. 121 days in jail is not sufficient. The state requests prison on this case, Your Honor, and the basis for the prison recommendation is the acts that the defendant engaged in. And although he may be seeking treatment now, his sought and desire to seek out those sexually abusive materials of children created a demand for those things, and that demand, at the beginning of it all, is abuse against children. And this such graphic, substantial abuse, because that's how far down in the rabbit hole he was that he was seeking out more and more depraved things. And the reason why the state wanted to show the court these things is because these things do have an impact. And when we only put it in words, and brush it off as child sexual abuse or child pornography. That's not sufficient. I feel exceptionally strongly about this. It was important that we argue out Joe because I think that the amount of time is not sufficient. Additionally, I'd note for the court, the parties did stipulate that violence was not used in this circumstance, but the court's not bound to that. I note that for the court. The court can make the decision. I think the light amount of jail doesn't really take into consideration the severity of this case. I think there are aggravating factors, such as the distribution. Now, I know he's engaged in treatment, but imagine all of those images of all of those children that he's seeking out. I understand he needs treatment. It's obvious, but I do not think that that's sufficient. Now, he was granted an exceptionally generous ability from the court to be out only after serving 121 days of jail. But this type of behavior and this type of charge demands, in the interest of justice for the children, that he be incarcerated in a Utah State prison. So that is the request that we have from the state, Your Honor. Thank you.
Ms. Isaacson?
Your Honor, Mr. Hoffman is 22 years old as he stands before you. He was 20 when he committed this offense. Our legislature has treated offenders who are under the age of 21 when they commit sexual offenses differently. There are different lengths of registration. I think the legislature has recognized that when offenses are committed when someone is younger, that the punishment and the consequences should not be as severe because of the immaturity of the defendant. As you know, he did serve 112 days in this case. When you gave him the opportunity to be out while this case was pending, he underwent a psychosexual evaluation and has been engaging in very intense sex offender therapy with Dr. Peter Byrne in Salt Lake. He has submitted to polygraph exams confirming that he has not had physical contact with minors. He is actively working on understanding how these offenses occurred. Dr. Byrne explained, we attached two letters from Dr. Byrne, one from January and then one from May, that just talked about how his behavior since he's been out has actually reduced his risk in the community by finding employment, becoming socially engaged, being in a relationship. He is in an appropriate, age-appropriate relationship with someone. I've seen many other defendants or people who are awaiting their case to be resolved go the other way. It can be difficult to find employment. They can be sort of defeated by the fact that they're facing these very serious felony charges. But instead, what we've seen from Aidan is him really working hard, again, to find two part-time jobs. He's super fortunate. His mother and father are here in the courtroom. As you may recall, they're from Maine. His mom was able to relocate temporarily from Maine to live with him up in Summit County. And I think you can see from the letter from them, this is not a family or a defendant who has downplayed or minimized the seriousness of this. We recognize that these images are terrible and that this pornography is terrible, that these images are awful. But this is someone who absolutely has not attempted to minimize. I think you saw in the pre-sentence report, in every single category, he was in the low range. I very rarely see that in a pre-sentence report. And they talk about him accepting responsibility, not minimizing. You can see it from Dr. Byrne describing it as well. And these are not parents who are in denial about how serious this is. They recognize that this is abhorrent behavior, that he needs treatment. Of course, he's going to have to register as a sex offender, which is appropriate. This is not someone who's getting a light sentence in this situation. As far as explaining the history or explaining the background, I think Aidan has said repeatedly, I'm not trying to make an excuse. I'm trying to explain the context in which I started looking at this material and sharing this material. It's always a challenge for the court to determine, what's the right level of incarceration? Does it make any sense to send someone who is 22 years old to the prison to be with those kind of other inmates who are significantly older for the most part? To me, that just doesn't make sense. If this was someone who we were worried about him engaging in treatment, we were worried about him complying, I totally understand. Or someone who has obviously if someone's perpetrated on an actual child, that's one thing. But we have polygraphs to show that has not occurred, thank goodness. And so I think this is a situation where Aidan has demonstrated over the last months that he's been out. He can follow the rules. He can comply. He's engaged and motivated in treatment, and he's not given up. Instead, he's really kicked into overdrive to try to be productive, to contribute to society. And of course, as we look at the pre-sentence report, we have guidelines for a reason. And the presumption with these guidelines is we start at the midpoint range, and that's why we made a recommendation consistent with that midpoint range. As APMP reviewed the matter, they did not find the aggravating circumstance that counsel is suggesting. Instead, they evaluated everything. They looked at all of the documentation. They looked at the reports, and they found it appropriate to recommend a 210-day jail commitment. I'm asking the court to consider imposing a jail sentence at that midpoint range with giving him credit for the time that he's served to keep him on track with treatment, with his employment. And so that's what we're asking.
Mr. Hoffman, is there anything you'd like to tell me before I sentence you?
Yeah. Since I was released, I've been engaged in intensive treatment. In that treatment, I've worked on being accountable for what I've done, and also I've learned about the abuse perpetuated through the viewing and sharing of child pornography and just how awful that abuse is. I wish there was a way to tell my past self how wrong all that was, and that these are real children who can't protect themselves, and I will always feel awful and never forget the things I've done. In the last 6 months since I was released from jail, I found work at 2 different jobs. I'm so fortunate that my mom was able to come out and live with me. I'm blessed and grateful for that. I'm working hard to build a new life here in Utah, starting in a state where I'm not from, and I'm 100% committed to completing therapy, complying with whatever restrictions, probations I'm given, and if probation allows, I'm planning and currently enrolled to attend college in the fall, where I was supposed to start last year, but this time with their online program. But that's all depending on the outcome of the situation. I think looking back, despite how hard this has been for me, there's silver linings with all this. And I'm grateful to some extent that law enforcement intervened because I needed help for something real, and it's something that's not normalized, something you can't talk about with people. You can't bring it up to your parents. You can't find help normally in society, and unfortunately I had to confront this problem in the worst way possible, but from here on out, there's no justification for what I did. I'm not minimizing what I did. I'm not justifying it, and I promise to be better, and I'm willing to do whatever the court sees fit for my circumstance, Your Honor.
Thank you. I did defense work. I've seen worse. That's not to minimize at all, Mr. Hoffman, what has happened here. Okay. You didn't perpetrate those 2 videos that I saw. You weren't the other person in the videos that's hidden and doing it in secret. That usually happens somewhere else. Happens in the U.S., happens in Eastern Europe. What you did was pour all that gasoline on those fires, because by viewing and sharing those images, you are stoking a problem that just seems to grow. And so you may not have been the other person in those videos. Your behavior fuels them in creating more videos, if that makes And weirdly, it's a huge problem in Utah, despite maybe people who would think otherwise. I see it in youth your age who have early access to pornography by videos and cell phones and sharing it at school. And I see it at the 70-year-olds that I send to prison all the time who convert that into actually perpetrating as well. And so the range here is concerning because you're starting out younger with more access than those old guys that I send to prison who are perpetrating in their adulthood and, you know, with their grandkids and other people. So Mr. Stocks' position on this, I think, is well-founded to say that there's really zero tolerance from his perspective as the county attorney for this kind of behavior. The reality is a little different, and I think the PSI takes that into consideration in its recommendation. PSI is a tool that says, you know, we took your age, we took your history, we took other people in your similar situation, and that's how we come up with this recommendation of jail time. I can't send everybody to prison who views child pornography. There aren't enough prisons. There aren't enough prisons for people who are severe, extreme viewers of child pornography, like you. There's just not enough room to view that. And, you know, I can appreciate you saying that you've done a lot of work. I think it's like alcoholism, and you may not, but the compulsion to view child pornography, scientists would say, may or may not be an addiction. I think it definitely reorders your brain in a way that you seek out the dopamine that viewing that pornography gives you, and you continue to seek out more and more dopamine. And, you know, like people who use a little heroin and then have to escalate that to get that same thing, I think people who view child pornography can, through their compulsion, rewire their brain in a way that you have to seek out bigger and greater and more serious things. I suspect this didn't start with child pornography for you. I suspect this started with age-appropriate adult, you know, pornography. In my experience, working with offenders, that's where it starts. And it escalates to these more extreme kinds for some people, for whatever reason it did for you. And so, you know, you're not the 75-year-old Mormon bishop that is doing this and perpetrating on kids and grandkids. You're not that person yet. I hope you never will be. Okay. But you're someone who had easy early access to something that I think is just terribly destructive for you and terribly, terribly destructive for those victims of those rapes that you were viewing in real time, or, you know, videotape rapes of those children. I agree with Mr. Stocks as well on the point that the words don't capture it. Deputy Levitt gets a lot of credit for the work he does. Well, he probably doesn't get enough. I can't imagine doing that job. It would take the kind of resilience that I don't think most people have to do that job, do it objectively, and protect children the way that Deputy Levitt protected children in this case. So kudos to him for being able to do a job that most of us couldn't do. The harm that viewing does, I don't think can be overstated because of how it fuels that fire for the people who are committing these kinds of, who are creating this kind of stuff. The other side of that, though, is you're young. You found yourself with too much time and too much access on your hands. You have parents who are obviously very supportive of you. I've read their letter. They're here today. They're well educated. They, I have no doubt, in their careers have seen the really negative consequences of this kind of stuff in real time with real victims. And they're here supporting you. You have an age-appropriate relationship, which is hard to come by for young men who fall down this rabbit hole. You have work that's keeping you more busy. I don't want to disrupt all of that stuff. The other thing is you have, I think, supportive parents and good attorneys who know how to do this job and got you into treatment early, and you've been receiving resources that you needed to help with this. But I do think it's a lifelong problem that you're facing. And much like alcoholism and heroin addiction, whether this is an addiction or not, I think it's a compulsion that nears that same level. It tells your brain that you need something more and you need something different, and children get raped because of men like you who encourage that kind of perpetrating. So I truly do hope that what your therapist says is true about you and the work that you've done. I commend you for the work you've done. It's not easy work. It's going to be lifelong work for you, though. I'm going to follow APMP's recommendation, largely, and I sentence you to up to 15 years in prison on each count. Those will run consecutively with each other. And the reason for the consecutive sentences is that the two videos that I saw meant that two separate children were raped at two separate times. Okay. And by fueling that fire, I think you put those victims and other victims at risk of the same thing happening over and over. And I'm not foolish enough to think that your arrest and your sentence is going to make any real difference in the world. I hope it makes a difference in this community by people who have seen what happened here and things. I'm going to suspend those sentences, though, and place you on probation with adult probation and parole for 48 months. The requirements of that probation are that you have a case action plan, that you complete a cognitive behavioral course as directed by APMP, that you have a mental health assessment and comply with the recommended treatment. APMP may be satisfied that the treatment you've already done meets that requirement. They may not. So if they think that you need other adjustments, they're going to make those recommendations. You'll need to participate in all sex offender treatment programs as directed by adult probation and parole. You will need to be employed full-time. If you, for some reason, aren't, you'll need to fill that time with appropriate business that APMP directs you to fill your time with. You'll have to have pro-social leisure activities as directed or at least recommended by APMP. I'm not going to impose a fine here because I think your treatment is expensive. I think it's more important. You're not to use or possess alcohol, any substance that's illegal in Utah, any prescription without a valid prescription. I don't see that as a problem for you. I see that as a place where some people turn when they don't get the dopamine that they normally get by these behaviors. You're to abide by all Group A sex offender group conditions while you're on probation. You're to register as required for any registries that APMP, the law requires or that APMP recommends. You're not to have any internet access without the approval of APMP. So what's the appropriate amount of jail time for someone who is obviously young and falls within this category? The Attorney General's office used to have a recommendation of 90 days in jail for child pornography cases. That's been adjusted somewhat. Now you have this recommendation that recommends 210 days with a midpoint of 105. You've served 112. Had you not done the work you've done, I probably wouldn't make the decision I'm making. I'm going to give you credit for the days that you served. Okay. So, does that mean I'm going easy on you here? I don't know.
Don't let you down.
I don't want you to engage in this kind of activity, obviously. You don't want to, I trust. Your parents don't want you to do that. There's enough here of a hammer hanging over your head, though, that if you violate the conditions of your probation, and it's a long probation, if you violate those conditions of your probation, I wouldn't hesitate at all to send you to prison if you've had the chance to correct your behavior and you don't take advantage of that opportunity. Okay. So credit for time served, 112 days is a lot of jail time. It's a lot of jail time for someone your age who comes from some level of privilege. And I trust that that's enough jail time to hammer home my view of all of this, which is consistent with Mr. Stocks's to a large degree. Practical reality here, though, is you got pornography access way too young. And unfortunately, it's such a rampant problem that not everybody can be treated as harshly as I think the crimes probably merit. So that's my decision. You have 30 days to appeal. If you disagree, you need to report to AP&P today, so your attorneys know where that's at. They can help direct you that direction. Just keep in mind, Mr. Hoffman, this is an opportunity for you to correct your behaviors, an opportunity to you to be an advocate for what is appropriate behavior for young men in your situation. You have more of a voice than some because you do come from a background of some privilege. You have parents who support you. You can be a voice for good. And if I see you again, I won't hesitate to send you to prison, and it's a long time. So don't mistake what is credit for the work you've done. Don't mistake that for a hesitation to impose the maximum sentence if I see you back.
We have one other issue, just the finding of no force or coercion. We had a stipulated agreement as part of the sentencing under Utah Code 77-41-105.
Yeah, I could not find force or coercion based on the evidence in this case for Mr. Hoffman's behavior so far. So.
Thank you, Ron.
Thank you, Ron.
Thank you. Good luck, Mr. Hoffman.